Yes, Mr. Herring.
My Lord, Mr. Knox was kind enough to indicate there were two matters that he didn't raise as part of his case. I'm happy for him to do it now. It'll take less than a minute, I'm told, unless the board would wish me to.
It will take less than a minute, Mr. Knox.
My Lord, I'm grateful. I mentioned there was a case about Section 10, subsection 6 of the Court of Appeal of Trinidad, and it's called Caroli, an Association of Technical Administrative Staff. If I can just indicate the relevant... I said what it said. Basically, it's all a question of how you construe 10.6 and so forth. It's not necessarily straightforward. It all depends on the nature of the complaint. It's inconclusive, but the pages 225 to 226 and then 237. My Lords, I don't know if you have copies before you, but it's just one case.
Is it in the bundle?
It's not in the agreed bundle. No, we found it over the weekend.
It was on our... I found it on my desk this morning.
Right.
It's just those paragraphs where it says, essentially, well, it may all depend upon the nature of the complaint you're making under section 10.6. If it's going to be, there was no evidence to support the finding, then that might be barred by section 10.6. But then it says, but we're not prepared to be prescriptive about the other types of complaint. So, for instance, excessive jurisdictional fraud are not necessarily within the purview of it.
Right.
But it's overturned. I don't think it's essential to the decision, but two judges deal with it. De la Bastide, Chief Justice, at 225 to 226C, or in fact 226G, and
yes.
Mr. Justice of Appeal Jones at 238H at 239.
Yes, thank you.
I'm not convinced I've got the case. Could you just give me the name again?
Caroli.
No. It's gone down here. Whoops. Yes, now I've got it. Thank you.
Oh, good. The other thing I was asked, and I couldn't find the reference, about the question of damages. What did we say in the Court of Appeal about damages and so on? There is a reference at bundle 2, page 679, at lines 43 to 49, where we did say in terms what the court could have done is make a note for assessment of damages to be assessed.
Could you give me that reference again?
679, lines 42 to 49. And there's just one other reference, tiny reference, at 604.
Sorry, that's 679 where?
679,
43.
lines 43 to 49.
Well, it says it could have done assessment of damages. Yes.
And 604, paragraph 41.
Mr. Cairns doesn't really say anything now, does he? I mean,
No, he just raised the point, that's what
yeah.
he doesn't answer all the points. And 604, paragraph 41, which is one of our submissions, where we basically said what the Court of Appeal went well beyond what we could have done anyway.
You don't argue that the order of the industrial court ceased at the date of that order, the order for payment of back pay ceased as at the date of the industrial court's order and could not be continued because all they were doing was awarding damages for violation of a discipline provision.
No, we didn't. No, we don't make that point. No. We don't spell it out. No.
Right.
But we just say that's what we could have done.
They could have done that.
We don't spell out, so to speak, the nature of the exact order that could have been made. That's the way I can say. No, I accept that.
Right.
I'm much obliged by that.
Thank you very much.
Just as you have the record, volume 2, I'd like to turn back to page 679. It's a point I may not need to come back to if I simply take you to it now. Page 679.
Yes.
Line 38. Question put, so it can be done in public law. And Mr. Khan, the proceedings in the industrial court are completely different in my submission from public law proceedings. And then the part which Mr. Knox referred to, so they cannot make a consequential order, and then reference to assessment of damages. But that doesn't appear to be a request for an assessment of damages, because as I've shown the board, in the written submissions, they were arguing for an outright success. That may have some bearing when we look at the case of McLaughlin and Jagru, which are public law cases. My Lord, picking up where I left off, could I invite the Board, please, to look at the Joint Authorities Bundle, Volume 2, page 1139. This is in Table 11, and is the decision of the Board from Mauritius in Danny Sylvie Marie.
Yes.
And it's really to deal with this point. If I could invite you to look at 1139, the bottom of the page. In that case, the Maltese Constitution letters patent provided, all questions which may arise as to the right of any person to be or remain a member of the Senate Legislative Assembly, and this the important bit, shall be referred to and decided by our Court of Appeal in Malta. And then if you look at the next paragraph, the Board held that the clear intention was that the Court of Appeal in Malta would have the first and only say on those matters with no further appeal to the Privy Council. The short point that arises from that is that it is not necessary to simply say that the order of the Court of Appeal is final. Different language can be used, and we have indicated that Section 18, subsection 1 and 2 is sufficient to deal with it. So you don't have to use the words, the Court of Appeal's decision is final. And we say that, more importantly, when you look at paragraph 48, the language used in the Malta statute was arguably less forceful than that used in Section 18 of the Industrial Relations Act, limiting the right of appeal to the Board.
Right.
We accept, of course, that Mr. Riley had the option to bring an action for breach of contract in the High Court, and had he done so, those rights of appeal to the Board are intact. But we say that for all of those reasons, it's simply not satisfactory to say that Section 18 did not exclude a right of appeal to the Board, because as a creating statute, it wasn't altering anything, it's creating a new jurisdiction. My Lord Wilson asked me about the bundle that we provided. I apologise that we couldn't provide it sooner, but I know that certain points may be raised against me in reply. That, for example, the point about the order of the Court of Appeal being final. But I said it would be brief. The single article we can find, which is the top of the bundle, the right of appeal from Trinidad and Tobago's Industrial Court. This is the only article we can find that deals with any kind of academic opinion. Just pause there.
Yes.
Yes. And it is really what it doesn't say that is what is important, because it talks about the right of appeal to the Court of Appeal. It talks about the concerns about that right of appeal, but it makes no mention of a further appeal to the Court. And if
it's so obvious that there's no further appeal, he didn't need to mention it.
Well, in an academic article, if one is talking about the rights of appeal and how they might operate, one might have thought that he would have mentioned, and of course, these matters can be reviewed by the Board. But again, even in academic consideration of this, there is simply no suggestion, no indication that there was a right of appeal to the Board. There is some highlighting on page 353 onward, but as I say, its value is in what it does not say.
But I mean, I've never heard it suggested that we're bound by what is not said in an academic article.
Absolutely, but that's quite right, my Lord. I agree. But what I was hoping to do was to provide something beyond the case law that might give an indication that there was no right of appeal to the Board, and it's the only article we could find, and academic opinion, such as it is, does command some attention, and we offer it for that value. But could I invite you now to look at the supplemental bundle, volume 3 of the bundle of authorities.
Do we have this electronically?
You do have it. It's page 1407.
Right. Yes.
And again, I take my Lady Arden's point that sometimes Parliament proceeds on the basis they know what the law is, etc. But when you look at page 1407, and you can see at the bottom of the page, it will be left-hand column, it will be remembered the motion seeking declaration on unconstitutionality of the Act reached the Privy Council. That is the only consideration, Lords and my Lady, of the Privy Council when the passage of this legislation was being discussed. And we have identified that particular case. I'm not going to take you to it, but the Board may wish to have the reference. It's in the first bundle of authorities, page 1092. I'm not going to take the board to it, but we've identified which case it is, and it's the case of Collymore versus the Attorney General. And that was a constitutional motion challenging the constitutionality of the Act as being ultra vires the Constitution. After that, could I invite you to...
Sorry, I'm simply not keeping up with it.
I'm so sorry.
I mean, what was the relevance of page 1407, which appears to be proceedings in Parliament, is it?
Yes, this is Hansard in the House,
Yeah.
dealing with the passage of what was then the Industrial Relations
Well,
Bill.
why are we concerned with that?
Well, we've
It's not a
referred
pepper and
you
heart
to
case.
it because we say that that underscores that the only consideration of the Privy Council was not in the context of an appeal to the board.
No, but again, we can't be,
It's a
whatever
pretty
Pepper
big
and Heart
point, isn't it,
says,
Mr.
we can't start looking at what Parliament didn't say. I mean,
Well,
you are making an awful meal with respect to this point.
all right, well,
I mean,
You've covered the ground. It's in your case.
Can I
You've
give
spent
my lords-
25 minutes
Yes.
on it, and it might be time for you to move on to the substance of the matter.
and I will take that indication, my lord, but could I give you these references without developing the point further?
Are they not in your case?
They're all there.
Well, then they're on the case.
It's page
I
1092.
think you're getting the message fairly clear.
I have, and I'm taking it. 1417, 1415, 1416, and 1448. That deals with the proceedings in the House, and then in the Senate, 1451, 1464, and 1465.
Right, well, let's leave jurisdiction and get on with the
Well,
other points.
yes, I'm reminded, I know that the point is going to be raised that we did not produce a speaker's certificate. Mr. Knox was kind enough to indicate that to me. We've made contact with Parliament, but
The surprise me is,
if it's not being raised, then I'll leave
No,
it.
it's not a discrete point. That's just by way of contrast with other cases.
Yes, right. Let's get on then.
Lord, can I am going to get out of it, my Lord, and I will, but could I just indicate this, because the Board has it in the bundle. There are two matters that the Board may wish to consider. The Equal Opportunities Act uses virtually identical language in the creation of the Equal Opportunities Tribunal in Trinidad and Tobago. That piece of legislation was passed with a simple majority, but the Board in Surat decided that that could be brought into law irrespective, it didn't need to be constitution compliant. The reason we say it is relevant, and I would invite the Board to look at it even though I'm not going to go into it in any detail, is that this particular statute, the Industrial Relations Act, was passed with the requisite majority if an alteration were needed to an appeal to the Board. The Equal Opportunities Act was not, and when you look at section 50 of that Act, it does exclude an appeal to the Board, but it's in identical language. And we say that that is an anomaly which the Board may wish to consider.
sorry, it's in identical language
Yes.
to what? To
To
section?
the creation of the Industrial Court in the Industrial Relations Act and then the appeal rights in section 18. The relevant section, so that the court has it, is section 41 of the Equal Opportunities Act, which is in identical language, or virtually identical language, to section 4 of the Industrial Relations Act, and then section 50 of the Equal Opportunities Act dealing with appeals, which is in virtually identical terms to section 19.
And you say that's been held to exclude the jurisdiction of the Privy Council.
Because when you look at Surat, which is...
Well, sorry, if you're making this point, you say that we're bound.
Well, can I invite the Board to look at Surat? It's in the loose bundle on the side table. And if I can give the Board paragraph numbers.
I haven't got it yet.
It should be immediately after the Equal Opportunities Act. this is the only reason we've taken this point, because if you look at paragraph 2 of the judgment, should be beginning the EOA was passed. 2 of the judgment, Lord Bingham. It was passed with a simple majority by both Houses of Parliament. Then if you look at paragraph 6, bottom of the paragraph, it then deals with, last couple of lines, an appeal lies from the tribunal to the Court of Appeal, whether as of right or with leave, on the grounds specified in section 50, subsection 2 of the Act. But subject to that, the orders, awards, findings, decisions of the tribunal in any matter may not be challenged, appealed against, reviewed, quashed or called into question on any account whatever, and the tribunal may not be subject to prohibition, mandamus or injunction in any tribunal on any account whatever. Section 50, subsection 1. The one difference...
So where do they decide that that excludes appeal to the Privy Council?
Well, I was going to come to that. The one difference, my Lord, is that section 50, subsection 5, which is not dealt with in the judgment, says, using the words Mr. Knox mentioned, the judgment of the Court of Appeal is final. And could I invite you to look at the legislation?
Yes, but sorry, is there something in this decision which says that it excludes appeal to the Privy Council?
Well, my Lord, this is how we put the argument. There's nothing that specifically says that, but this is why we drew your attention to this passage, because there is no mention of a further appeal to the board.
But then no one suggested there was. I mean,
Well,
it's only of relevance
it is
if the board considered the point and decided. If they didn't consider the point, it doesn't help us at all.
Could I invite you to look, please, at the Equal Opportunity Act, because this was the point raised against me about what the Act should provide. It must state that it is going to alter the Constitution, etc. Yeah. But if you look at the very first page of the Equal Opportunity Act, the preamble, this is page 6 of the Equal Opportunities Act itself.
Yes.
It doesn't contain any reference to altering the Constitution or altering any rights of any kind. And that was one of the complaints in Surat. The Attorney General considered that unless it had that, it could not be Constitution compliant. And the short point is that where it is said against me that the Industrial Relations Act should make provision that it is inconsistent with the Constitution in a material respect, having the special majority, we know that this has been held constitutionally compliant without it, and it creates a court, creates rights of appeal. But as I say, the one difference, and if I could invite you to section 50 of the Act, it's page 31 of that document of the Act itself.
Yes.
The one difference is subsection 5, which is not in the Industrial Relations Act. A decision of the Court of Appeal in respect of an appeal from an order or award of the tribunal shall be final. That is missing from the Industrial Relations Act. But as I say, if that section is effective to debar appeals to the board, it's not been passed with the requisite majority. And it doesn't declare in the Act that it does. And so it's not necessary, we say, for the Industrial Relations Act to say that for our purposes.
Right.
Yes. Now, could I take the board now to the merits, which is the main argument? Sorry to have spent so long on the jurisdiction point. This deals with issue 2, 3, 4 and 5. It's essentially the same argument that goes across all of those issues. Prior to the hearing, there was direct reference to reinstatement and back pay, and so we say it was a live issue at the outset. Could I invite you to look, please, to the record, volume 1. And it's page 99. And it's not very clear, unfortunately, in the print, but you can just make out that this is a letter that is dated the 12th of March 2002, which was a further request, a second letter requesting reinstatement without loss of benefits.
2002.
It appears to be the 12th of March 2002, and it's signed by Flavius Nurse, the General Secretary of the Union. Then if you turn to page 103,
We don't need to read it.
no, it's not necessary. It's really to give the board the references. If we turn to page 103, the point about the continued suspension of the worker without pay is again made, and this is on the 6th of September 2003. 2004, forgive me.
Okay.
Now, the board will probably have seen reference throughout the record to the interpretation application, and it appears that what had happened is that the union had made an application by letter, 23rd of January 2003, to the Industrial Court for an interpretation of the collective agreement in relation to indefinite suspension without pay. But what the appellant did was indicate that the way in which it could go forward was to expedite the proceedings, that is, the disciplinary proceedings, and so that was not pursued. But it would have been obvious, we say, from that, and it's highlighted in that letter, that reinstatement, the suspension without pay indefinitely, were live issues. It's 4 lines down from the second paragraph. Beginning that the union had previously made.
Yes?
Now, the point is already made in relation to section 47 that the collective agreement is part of the employee's contract. But again, we say that there is something to be said about how this proceeded, suspension without pay, because it is not provided for in the Article 16, the grievance procedure with which we are concerned. It does not say you can suspend a worker without pay. There was some evidence from the original CEO, Mr. Samuel, suggesting, well, I understood that that's what it could mean. But we say that unless it expressly says that as a term or condition of the contract, you cannot suspend without pay. And we rely, again, this is a short point, there is the authority of Camaruzan, which is in the bundle which we've handed up. And it's a decision from Belize.
I trust that all of these will be sent electronically.
Yes, they will.
Yeah.
They will. I apologise, we weren't able to do it before today, but
Well,
they will be.
I hope I don't sound too churlish by saying this really isn't good enough for Mr. Beharila. Yes, all right.
What's the name of this case?
This case is Mohammed Camaruzan. It's a decision from Belize. And insofar as it may be relevant, because this was, we say, a live issue at the outset in these proceedings, if you turn to page 32, bottom of the page, and this is to deal with the point made in relation to the common law approach in relation to mitigation of damages, etc. What the court there decided was that under common law there is no inherent power to suspend an employee without pay, and cites various authorities, including some of the English authorities. Went on to say, so an unpaid suspension may well amount to a breach of the employment contract by the employer to pay the salary due to the employee during the suspension, and that any restriction on the claimant's right to his full salary during the period of suspension must therefore be provided for by statute before the defendant can impose it on his salary. I have not cited nor had counsel refer the court to any such statutory restriction in this case. There are then some consideration of South African cases, but they also support the proposition that suspension pending investigation and disciplinary hearing, the situation Mr. Riley found himself in, must be on full pay, since the suspension is not taken as a result of a disciplinary sanction which is imposed afterwards. And then paragraph 34, bottom of the page. The claimant, though suspended, continued to be an employee of the defendant throughout the period of his suspension, and as such he is entitled to all the benefits of that employment, unless limited by statute. As I have said, the court has not been referred to any statutory restriction in this case. It then goes on to deal with the particular case before it. So what we say is that suspension without pay was impermissible anyway at common law. The Act itself doesn't provide for suspension without pay. Thus, the suspension should have been, absent either statute or something in the agreement to the contrary, on full pay. And all of these matters, although not expressly set out in the judgment of the Industrial Court, must have been, as a specialist court, at the forefront of their minds. Mr. Riley was thus, in any event, entitled to all of his pay and benefits, at the very least to the date of his termination on the 4th of April 2008, which was the date they gave in their letter. Can I now invite the board to page 109 of the record?
That wouldn't exclude a duty to mitigate, would it?
I'm going to come to deal with that. It wouldn't on the face of it, but if, as we argue, the industrial court was freed from applying the common law concept of mitigation of damages, then it didn't have to.
Indeed.
It could take it into account,
yes,
but it doesn't have to decide it on that basis. And if we can go to page 109 of the Record of Appeal, this is a letter from Mr. Murray, 27th of June 2006. Volume 1, page 109. And again, a letter to the disciplinary tribunal chairman. Last two lines of the first paragraph. Additionally, no date has been set for continuation of the tribunal, which is causing undue stress and strain on my client, who has been, and this is the important bit, unpaid suspension since on or around May 8th, 1999.
Wasn't that obvious anyway?
I'm so sorry, Mother?
Wasn't that obvious anyway?
Well, we would say it was obvious, but it was emphasised in this letter during the proceedings. Now, can I now invite the board to look at...
Sorry, the slight difficulty with this that I've got at the moment is that we don't really know quite what the reason for the 5-year duration of that hearing was.
I can summarise it in this way. There were a series of adjournments throughout the disciplinary tribunal hearing. A number of applications were made by Mr. Murray when the bias point arose when the then chair, Miss Alexander, was appointed the CEO. Because the structure of the decision-making was that a person would be appointed to chair the tribunal, would submit the report to the CEO, and the CEO would make the decision. And the concern was that she couldn't act in both capacities. But that was one of the applications. But then there were a series of other adjournments at the behest of the appellant during those proceedings, and then non-effective days as well. I say this very respectfully to Miss Alexander. It was not case managed, if I can put it that way. There was no real timetable set at the outset as to what was going to happen when, and that may have had an impact on why it took so long. In the end, Miss Alexander explained that because of the complexity, as she described it, of the issues that arose during the tribunal, she could not produce a judgment extemporaneously. She could only take a year to draft it, which is what we understand.
Take some time or something.
She took some time. And she submitted it to the CEO about a year later, and then I think about a month after that, the CEO issued his decision. I hope that's a sufficient summary. In relation to the Act, could I invite the board now to look at the Industrial Relations Act? And straight away to look at page 846 in the bundle of authorities. And we say that this is important, which is why we come back to it. It's the definition of trade dispute or dispute subject to subsection 2. It means any dispute between, and these words, any dispute between an employer and workers of that employer or a trade union on behalf of such workers, connected with, again, wide meaning language being used, the dismissal, employment, non-employment, suspension from employment, which we emphasize, refusal to employ, re-employment, etc., or reinstatement of any such workers, including a dispute connected with the terms and conditions of the employment of labour of any such workers. So where the appellant says that the trade dispute number 1 ought to have been confined, we say that that's not right, that the definition of trade dispute is wide enough, using the language it does, to refer to any dispute that is connected with a dismissal. One observation which may assist the board. Dismissal is not defined in the Act as such. They don't use, for example, the words constructive, unfair, wrongful. They simply talk about dismissal. And where they have referenced dismissal, what they appear to be talking about is dismissal in whatever circumstance it arises, whether directly on a complaint or indirectly as a result of a complaint. In relation to the scope of the hearing, could I invite you to turn to page 862, same bundle. And it's section 17 of the Act, 862 in the bundle. The court shall expeditiously hear, inquire into, and investigate every dispute and all matters affecting, and this is the important part, the merits of such dispute before it, and, without limiting the generality of the foregoing, shall in particular hear, receive, and consider submissions, arguments, evidence made, presented or tendered, whether orally, and perhaps this is the important part, in writing. And we emphasise that particular section because we say that it was wide enough to include the long unpaid suspension that lasted throughout the disciplinary process, which we say was akin to a dismissal, and the ultimate decision to dismiss. It all arose out of the same complaint of delay by the tribunal, and the court could not ignore it. It was required by virtue of section 17 to consider it. In any event, if you look at page 888, same bundle, and it's section 52, subsection 1, it's been touched on already, but it's worth looking at, in particular 1C. A report of a trade dispute shall be made in writing and shall specify the following matters. Subsection C, particulars of the dispute stating in general terms. It doesn't have to spell out every detail, the nature and scope of the dispute. So if we turn back to the record...
What point are you on at the moment? I mean, you're showing that if everyone had wanted, or you could have combined the second dispute into the first dispute.
Well, what I'm illustrating...
Which, that's fair enough. But problem is that didn't seem to be what anyone thought they would do until afterwards. But in fact, afterwards, the other side effectively said, well, now you're stuck. So does this point arise anymore?
Well, my lord, since the point is made against me that the first dispute was confined to the mere fact of the delay, as I understand it, and did not include the termination, we're simply showing, by virtue of these particular references, that it was wide enough to include the dismissal if it arose from that. And that's all it goes to.
So why did the industrial court refuse consolidation?
I think the enthusiasm of Mr. Murray, because he strenuously objected to it. But I should also indicate, my lady, that Mr. Murray conceded it would be sensible to consolidate the two, but the application to consolidate was made long after the industrial court had begun its hearing, and he felt that he was prejudiced if it had been joined at that stage. That was the submission in a summary that he made. And so it should have been done really at the outset when the letter was sent terminating. But it's not as clear-cut as saying I don't want it joined. He was saying, well, I could see the logic of it being joined, but the application is being made too late. We're already into evidence. In relation to the report, and it really seeks to link the legislation, the legislative provisions we've referred to, if I could invite you to look at page 34 of the record. This is the letter to the Minister from the Union, 23rd of March 2007. And it goes on to speak about the trade dispute. The trade dispute is over the failure to follow the grievance procedure, Article 16 of the collective agreement in Daniel Riley's tribunal. So it doesn't go into any detail, it simply complains about the tribunal. It's very general in its terms, and then when you turn to page 36, which is the reference by the Minister to the court, again, it is in general terms, failure to follow the grievance procedure in respect of the tribunal of Daniel Riley. Now, we say that there is no need and was no need to set out in detail that this matter concerned the dismissal, because it's common ground between the parties that Article 16 required, if you were going to suspend the employee, to commence the disciplinary tribunal within 10 days. And then, when you've completed it, to deliver your decision within 10 days. So it cut across the entirety of the disciplinary process. And that, we say, was sufficient to include the termination or dismissal of Mr. Riley. It couldn't be otherwise, bearing in mind that when the industrial court began hearing the trial, Mr. Riley had then been dismissed. In relation to the point about being able to make representations, natural justice, they didn't have the opportunity to make submissions about the remedy. We say that that is wrong, and we say that the appellant knew at the outset, before the trial began, that rendering the decision of the disciplinary tribunal a nullity was a possibility. And the reason we say that, if I can take the board to page 37 of volume 1 of the record.
Yes.
This is the first skeleton argument, the main skeleton argument, concerning this first dispute. And if you look at the subject matter,
Yes.
dismissal of Mr. Riley.
Yes.
It's dated the 21st of April 2008, and if you then turn to page 40 of the bundle, paragraph 10, bottom of the page, states the decision regarding, this is the decision resulting in termination, was conveyed to the work on the 4th of April, and as such the issue giving rise to this matter no longer exists. But then, on the very next page, page 41 of the bundle, as most skeleton arguments in modern practice tend to do, they deal with a primary position and then they deal with an alternative. And if you look at paragraph 12, the employer argued that even if the procedure adopted in exceeding the period of 10 working days in rendering a decision is considered to be improper, which is denied, improper procedure, and this the important part, is not sufficient to nullify any decision, since the consideration that would be relevant is whether the outcome would have been different had the procedure been followed. So the appellants knew and dealt with the issue of the decision to terminate, because they knew that if the industrial court, as it eventually did, rendered the entire disciplinary process a nullity, the dismissal could not survive it. And they were arguing against that. There'd be no reason to do so if that did not arise. And just to give the board the reference, in fact it may be worth looking at it, it's in the authorities bundle, first volume, and it's page 856, subsection 5. It's really to give the board the reference. If it's being seriously suggested that the appellant did not have any opportunity to deal with the potential remedies or relief orders that the industrial court could make, We say that that is wrong because when you look at subsection 5, section 8, subsection 5 on page 856, the court can require evidence or argument to be presented in writing and may decide the matters upon which it will hear oral evidence or argument. So it was open to the appellant to say, well, look, this is our primary position and this is our alternative position. And if you were to rule in favour of Mr. Riley, then he would not be entitled to reinstatement, he would not be entitled to back pay, but he may be entitled to damages. None of that was done.
So this is the statement of case by...
Evidence and arguments,
on behalf of the Chief Personnel Officer.
That's correct, yes. 21st of April 2008.
Do we have the equivalent one on behalf of the union?
Yes, I'm about to take the board to it now. If we turn to page 85, this is the union skeleton. There is reference, paragraph 3, forgive me, it's page 85, volume 1, paragraph 3, employed on or around 1984. Paragraph 7, suspended duty. Paragraph 8, reference to reminding the corporation of the dismissal of the matter and the need to reinstate the worker. And I've taken the board to the correspondence relating to that. Paragraph 10, lengthy period of time for a matter involving $176.40. The worker had been on unpaid verbal suspension since 8th of May 1999. And then when you turn over the page to page 87, paragraph 15, the union contend that the verbal suspension of the worker from May 8th, 1999 to when the tribunal ended was harsh, oppressive and contrary to good industrial relations, borrowing the language from the statute. And then paragraph 20, which has been touched on, the union does make a submission about the appropriate relief, and we accept that it says fine to be placed on the employer and the worker to be paid damages. But here we say, firstly, the union did address the relief that they were seeking. They didn't make any long submission about it, but they touched on it. And there's no reason why the appellant could not have done the same, even in response to this particular skeleton, to say, well, damages would not be appropriate, or what would be appropriate, for example.
Well, it's one thing to say that they touched upon it, but they touched upon it extremely lightly, Mr. Beharry.
Yes, I should have said touched upon it extremely lightly.
I mean, they didn't confront the question,
No,
which
they
seems to be absolutely central. Was there to be any mitigation of damages by reason of the earnings that Mr. Riley commanded during the period that he was suspended?
Yes, and
I mean, that seems to be an absolutely elementary point, isn't it?
it is, but if it's right that they needed to take into account mitigation of damages or giving credit. And this is where we say the answer is in the legislation. Because if I could take the board back to
But I mean, while we're looking at the papers,
yeah.
I mean, there was evidence given by someone specifically on what he was earning.
Yes.
And presumably everyone realised why that was being given was because it was thought to be relevant to the level of any damages.
I can deal with it in summary because it is in the record to answer my Lord Calmer's question. The answer was yes, they called Warrant Officer Dillon to give evidence of the earnings with the Defence Force as a reserve officer. It covered a period of roughly 10 years. The issue it appeared to go to, certainly in argument, was the issue of mitigation of damages. However, there is a particular matter on the evidence, which I think I should take the board to now, that may explain why the court ordered reinstatement and back pay. Could I invite the board to look at...
No, my point was really to ask you where in all these submissions does Mr. Murray say, well, we've heard that evidence, but it's not relevant because, or you should take it into account in this way or that way.
Answering my Lord directly?
No.
There isn't one.
I thought not. Thank you. That's all
I wish I could
wanted
take
to,
it through, but
be
it's certainly not dealt with directly. But we say it doesn't matter because if you look at page 856 of the Bundle of Authorities,
Yes.
even if the parties had made submissions on the appropriate relief to say, well, we consider reinstatement appropriate or not appropriate, etc. When one looks at subsection 3 of section 10, the powers of the court could not be more clear, irrespective of any submissions they would have received. Notwithstanding anything in this Act, or in any other rule of law to the contrary, the court in the exercise of its powers shall make such order or award in relation to a dispute before it as it considers fair and just, having regard to the interests of the persons immediately concerned, Mr. Riley, and the community as a whole. And then it goes on to speak of acting in accordance with equity, good conscience.
Which provision is it, please?
Oh, sorry, it's page 858, and it's the Industrial Relations Act, section 10,
58,
subsection
sorry, it was
3.
You said
856.
856, I think, sir.
I'm so sorry, 858.
We've got it now.
And it's subsection 3, paragraph A.
Yes, thank you.
And what we say that makes clear is that irrespective of what a party may say, well, this is the remedy we want, the court itself has to determine what is just and fair in the proceedings before
You're
it.
saying that it says they can suspend all the normal procedural features of natural justice and everything else. And
No, not at all.
Do what they like.
Not at all. And this is why I say that the opportunity to make representations was available to the appellant, as it was to the
Only if they know
union.
what's in issue, only if they know what the tribunal is thinking of doing.
Well, that may be right. But when you bear in mind the overall timelines with which we are concerned, we say that it is pretty obvious why the board would have ordered reinstatement and back pay, as opposed to damages, because the length of time this man had been on unpaid suspension simply could not be explained. It wasn't justified. And
But evidence, as my Lord has pointed out, had been given about the amount of money that he'd earned during the time of his suspension. Now, unless they address that question, surely it's bound to come into the reckoning, is it not?
well, my lord, it certainly has to be considered. I accept that. It's a relevant
There's
consideration.
no evidence that it was considered.
We say that it couldn't have been not considered because they called evidence about it.
Yes, but there's nothing in the judgment to...
No, there's nothing in the judgment, but there is in the record, and perhaps I can take the board to that now. I missed my...
Was it ever said that any award of back pay or damages should be limited to take into account earnings through any other source? Was that point made to the...
I don't think it was certainly covered, I think, in submissions by the appellant.
Otherwise,
not-
they wouldn't have called the evidence.
Yes, because that's what it went to. That's what it went to. But quite apart from that, it may be while we're looking at the authorities, I've taken you to subsection 3. Can we look, please, at page 800, forgive me, it's the second bundle of authorities. Record. And it's page 1110. Now, I'm seeking to deal with this issue of mitigation of damages stroke giving credit. The industrial court, as I understand it from my learned junior who practices before that court, generally gives extempore judgments. So written judgments are not available in every single case, and that's not unusual. But if you look at the case of Illuminat, which is at page 1110, this is tab 16, volume 2, this was a separate judgment given for the order for compensation in this particular case. It's dated the 22nd of September 2011, and it obviously predates the decision in Mr. Riley's case. And if you turn to page 1111, bottom of the page, quoting from President Khan, Banking Insurance General Workers, In assessing damages for a dismissal which is found to be harsh and oppressive and not in accordance with principles of good industrial relations practice, a number of factors have to be considered. 1, the immediate loss of wages. 2, the manner of the dismissal. And this, we say, relevant for us. 6, the loss of pension rights. And 7, any other loss suffered as a result of dismissal. Now, the board asked the question very early on, well, how old is Mr. Riley? And the difficulties that he faced is that, if I can give you the chronology, at the time he was employed, he was 27. That's 1983. When he was charged in 1999, he was 42. When the appellants lodged their notice of appeal to the board, he was 58. And by the time he was able to retain attorneys, those who instruct me, he was 60. And as I've said, he's today 63, turning 64 later this year. Now, when one looks at the factual matrix in this case, the delay, the length of time, the length of the disciplinary proceedings, the fact that he had been suspended without pay, all of those factors, we say, mitigated very powerfully in favour of an order for reinstatement and back pay. And I'm going to take the board to certain parts of the record that deal with this, but as we understand it, the two orders made by the Industrial Court, the first is for reinstatement, the second is for back pay plus emoluments and other contributions. If the board sends this case back for a damages assessment, he's not going to get his pension, insofar as he may qualify for one. And coming to what may be the real issue for Mr. Riley as to why he has seen fit to defend this appeal to the board, even without union assistance, this is what is now at stake. Because if the order for reinstatement and back pay is reversed and it's sent back for an assessment of damages, yes, there may be evidence called and yes, there may be submissions made. But as far as any pension rights are concerned, those are now going to have to be expressly dealt with and may not arise at all.
Why can't he use damages?
Well, this is the difficulty. He'll be back at the starting marks when, if the board dismisses the appeal and upholds the orders, he'll have to have reinstatement, he'll have to have his back pay at least till the age of retirement, and if that is age 60, which it may be, we don't know, and I'm going to say why I don't know, then at least he will get his pension, which will run from that date. We also say it's important for this reason. He could raise it, as my Lord Kitchen has asked, and say, well, look, this must be included in the order of damages. But the way in which this case has proceeded, and it's no criticism, it's simply the chronology, it also puts Mr. Riley back in the position where, if the appellant disagrees with the assessment of damages, there can be an appeal. And this may explain, I hope, why I took the jurisdiction point. It also could take us back here. And that, we say, is a consequence we should avoid. But in any event, could I take the board back to Illuminat, which is page 111. I've taken you to the factors. Can I invite the board's attention to the first paragraph, the reference to mitigation of damages by President Khan. Could I take the board to page 1118?
Yes?
And what we say is that when you look at the second paragraph, beginning with the words, our position is different, having reviewed the position on mitigation of damages and the application of that common law principle, they say as such, Our position is different. We, as judges of the industrial court, are confronted with the task of assessing damages in dismissal cases. We are bound to ask ourselves, in light of Section 10.3 of the Industrial Relations Act, whether, and if so, to what extent, the common law principle of mitigation is relevant, or whether that rule should be disregarded as any rule of law to the contrary, leaving the court free to make such order or award as it considers fair and just. And this is why I took the board to Section 10, subsection 3. Having considered various things, including the intent of Parliament, and it goes to the bottom of the page, last line, in the view of this court, the intent of Parliament in making specific reference to any rule of law for the assessment of compensation or damages, and empowering the court to substitute for any such rule of law assessment, opinion fair and appropriate, frees the court from the application of what Justice Diplock referred to in Schindler as the duty to mitigate the workers' damages. We are of the view that this court has over the years misled itself on this question of mitigation of damages in dismissal cases, and it is not for the court to continue to labour under that error or to apply that common law rule only for the reason that it was applied in the past. And then ending with this, it is sufficient to say that the court fell into error insofar as it applied the principle of mitigation of damages before, and that error is correctable by the court itself.
But do you accept that the court has to address the question whether there should be allowance made in mitigation of damages?
It has to take it into account, but we answer that question directly, my lord, that when the point was raised by the appellant as to mitigation of damages, the evidence of Warrant Officer Dillon, the court was saying we would take it into account, and it was part of the evidence in the case. And so we can't, the board should not assume it disregarded it simply because it's not mentioned in the judgment.
But it failed to give any reason.
Yes.
For dealing,
It's got to ask itself whether it's fair and reasonable to make this particular award of damages. That must surely require the court to deal with the question of whether any mitigation of the damages claimed, well, there's no question as to whether they were in fact claimed, but any mitigation of the loss of earnings was appropriate. It has to do that if it's going to address the question of whether it's fair and reasonable, doesn't it?
The only way I can answer it, my lord, in light of how this case proceeded, is that the evidence was called and the industrial court would have had it in mind when it fashioned the remedies that it made. I accept it wasn't dealt with in the judgment. I also accept that it appears that when they gave the judgment, they set the remedies there without a separate remedy hearing. And I accept that. But where we have got to now, bearing in mind, as I've tried to show, that the parties could have made submissions early on in writing as to what the appropriate remedies might be.
Surely your better point is that they could have taken the point in the Court of Appeal.
Well, they could have also, and we've made this point in our written case, because the formality before the industrial court is flexible, they could have sought a relisting to say, hang on, you have not given us an opportunity to address the order. They did not do that. Instead, they sought to appeal. And to answer my lord directly, yes, they could have raised it in the Court of Appeal to say, well, look, the appropriate course now is not to give him reinstatement and back pay, but actually damages. But this is why I showed you at the beginning of my submission. They argued against damages. They wanted an outright success in the Court of Appeal. So even if they forgot to raise it in the industrial court, which we say they still could have, they didn't raise it in the Court of Appeal, and it should not be open to them raising it now.
So you tell us, and you've got a junior who knows about these things, you tell us that it is possible in the industrial court, after having received a judgment, to say, forgive us, but I wonder whether we could address you on a particular point that you haven't dealt with.
Yeah,
that is legitimate.
To have a hearing on the
yes.
remedy. Yes. If I can take you back to Illuminat, if you look at page 1111, it's the first paragraph. In that case, that was the position that was adopted. And so we don't say that is not a course that could have been taken. Because they'd given the judgment on the main matter earlier, and this judgment was purely as to the orders.
Well, that's where the court retained jurisdiction.
Yes.
This is a slightly different
situation.
I mean, so often in the Privy Council, we have complaints about things that one says, from an English and Welsh perspective, why didn't you apply to the court on the basis that they hadn't considered that? Often the Court of Appeal, sometimes the first instance court. And I get the impression I have got the impression that that is more difficult, perhaps, in some of these overseas jurisdictions than it would be in England and Wales.
Well, it could be, but speaking for Trinidad and Tobago, as we understand it, because the court is freed from legal form and technicalities,
Yes.
the legislation provides, you can seek a relisting to say, hold on, we've not been given an
Right.
opportunity to address this, may we have that
Okay.
opportunity? And so we say that that was an opportunity available to the appellant and they did not take it, and of course, as my Lord Carnworth has mentioned, it wasn't raised in the Court of Appeal. So having both of those options available to them, how can it be right that they be permitted to raise it now and send it back for a damages hearing?
Maybe said this is a point of principle. We went about it the wrong way.
Then, if it was a point of principle, it should never have been used to dismiss the second trade dispute, we say, because they relied on the validity of the orders made in the industrial court to secure the dismissal of the second trade dispute. They were not saying that there was anything unjust about the order or that it was somehow made invalidly. In fact, they said, well, this is a proper order, and it's a proper order that enables the court to use its powers under subsection D to dismiss the second trade dispute. And so I appreciate that that touches on issue 5, which we raise, the court can dismiss the case if there's been no substantial miscarriage of justice. But this is why I said I would deal with issues 2 to 5 altogether, because you cannot ignore the second trade dispute, which, although expressly dealt with termination, Mr. Riley had no opportunity to pursue that. Article 16 of the grievance procedure, even if a person has been, I don't want to use the word convicted, but found liable, you are still entitled to make representations. One of the key features that was considered by the industrial court, a number of questions, was did Mr. Riley have the opportunity to make any representations on the order to terminate? And the answer was no. So I suppose in a reverse way, exactly what the industrial court has done, had a hearing and given a remedy without hearing the appellant on the remedy, they had a hearing with Mr. Riley, and then found him liable and dismissed him without giving him any opportunity to address the dismissal. Which, when you look at Article 16, doesn't seem to be consistent with that. So, in balancing the natural justice requirement, in balancing the rationality, but coming back to Section 18, whether there's been a substantial miscarriage of justice, when you look at the entirety of this, we say that there is no substantial miscarriage of justice here, whether it be a point of principle or not. And just dealing with the point of principle, Section 18 specifically, we've looked at this, Section 18 says, even if that point of law might have been resolved in favour of the appellant, if there's been no substantial miscarriage of justice overall, that doesn't mean they're going to succeed in the appeal. And the Court of Appeal could dismiss the appeal as we invite the board to do in this case.
Well, I suppose your argument can be put this way. The appellant submitted that the ruling, the first ruling, was dispositive of the second claim, and it doesn't lie in their mouth now to say, because they positively asserted that was correct and that disposed of the claim, it doesn't now lie in their mouth to say, oh, well, the first ruling was wrong after all.
We agree.
And certainly it doesn't amount to a substantial miscarriage of justice. Well, where are we now, Mr. Bahela?
Lord, can I deal with a few references in the record, because it may be of assistance. Can I just bear with me for a moment with my... could I give the board this reference? There's no need to turn it up, but it's really to distinguish the point. The appellants rely on Hydro Agri, which is at the second bundle of authorities, page 1186. And as I understand it, they seek to rely on that for the purposes of saying that, or arguing against the orders made. But we would say you can distinguish that because that was an interpretation application concerning a collective agreement. And even though in that case the Court of Appeal said that no damages were appropriate, that's a very different case to the one you're dealing with. Didn't concern dismissal. Just dealing with the natural justice point, this is issue 3. I've touched on it already, but if I can turn to that now. The board has, the appellants have relied before the board on two public law cases, Jagru and McLaughlin. Could I invite you to look at both of those now, please?
What's your submission going to be?
Well, essentially, these are public law cases. But in any event, in the case of Jagru, there were specific reasons why you would not order reinstatement. And in McLaughlin, the board probably had in mind something similar as we are considering here, bar the mitigation of damages point, that unless McLaughlin had retired or been lawfully terminated, he continued as an employee and was entitled to be paid as such. So even those cases which are public law cases, not exercising the special jurisdiction that the industrial court was, we say that those are not authorities upon which the appellant can properly rely. And if I could take the board to those now. Jagru is at page 1189. And the head note is helpful. Matter should be remitted to the High Court for an assessment of damages. And they rely in particular that the Privy Council accepted, this is the passage immediately above, the Privy Council accepted that a declaration that the appellant was still a member of the teaching service would represent a high degree of unreality, as would any order for his reinstatement in office. But we say that there are good reasons to distinguish that case insofar as it, one, is a public law case, but two, if you turn to page 1202, it's paragraph 41 on page 1202. In these terms, Lord Walker, this is not an appropriate case for the Lordships to embark on a full analysis of the sometimes obscure border between the tenure of statutory office and employment under a contract of service. Even if the position is regarded in terms of statutory office regulated by public law, and this the important part, it is a matter of judicial discretion whether a litigant who has been unlawfully dismissed or compelled to resign and has in fact ceased to perform any of the duties of the office should be granted an order for reinstatement. So it is discretionary, and we say that the industrial court, having regard to all of the matters that were raised before it, cannot be criticised for exercising their discretion in the way they did. In fact, it should be remembered that they did not accede to Mr. Murray's submission on behalf of Mr. Riley for damages and gave a different remedy that they considered fair. There's also a distinction to be drawn about the element of high degree of unreality. In this particular case, this is the case of Jagru, Mr. Jagru was unfortunately very ill. He had suffered from health problems that resulted in the amputation of both his legs, and there was a real consideration, paragraph 43, that he would not be well enough to discharge his duties. At the time Mr. Riley obtained judgment from the industrial court, there's no suggestion that he could not have resumed his duties. He was a driver. In fact, the evidence of him driving a taxi right through that period showed that the thing that he was doing for the corporation is the thing he was doing right the way through. And as I understand it, for the Defence Force, driving was also included. I think that was one of his duties. Yeah, driving was one of the functions he would perform with the Defence Force as well. The next case of McLaughlin, we say again, does not help. This is at tab 23, page 1236 of the authorities bundle.
Yes.
And very bottom of the page, decision to dismiss the plaintiff and dismissal itself were without legal effect, but there was no analogy with wrongful dismissal, where a dismissal might be unlawful but nonetheless effective, and that accordingly the plaintiff was entitled to recover arrears of salary and pension contributions since 1st April 1999 until such time as he resigned or his tenure of office lawfully came to an end. And in that case, if I can just invite the board to look at page 1238, the very next page at lettering F. As a matter of factual comparison, Mr. McLaughlin, in the procedure for the purposes of retiring him, if they are abolishing the office he held, he was entitled to make representations. He was not given that opportunity, and so his dismissal occurred in breach of the rules of natural justice. And this is why we have drawn attention to the board in relation to how Mr. Riley was dismissed. Because although he's not had to raise this point, that is in fact what happened. He was not given an opportunity to address the ultimate remedy. And then if you turn to page 1243, conclusions of the board, paragraph 14, it's a settled principle of law that if a public authority purports to dismiss the holder of a public office in excess of its powers or in breach of natural justice or unlawfully, categories which overlap, the dismissal is, as between the public authority and the office holder, these the important words, null, void, and without legal effect, at any rate once a court of competent jurisdiction so declares. And this is where the appellant, having accepted before the board that they do not argue with the decision of the industrial court that the proceedings are a nullity, this means that the dismissal has to fall away. And so the office holder remains in office, following McLaughlin, entitled to the remuneration attached to such office, so long as he remains ready, willing, and able to render the service required of him until his tenure of office is lawfully brought to an end by resignation or lawful dismissal. So even applying the public law principles from that case, that would favour Mr. disposal of the industrial court here. We would could I invite the board to look at the record, volume 1, and turn to page 133. We've already referred the board to the various references to reinstatement and so on, but insofar as there was express consideration of the issue of reinstatement, page 133, line 16 to line 37, Judge Aberdeen, they go on to say, as I understand it, that because you failed to do that, that nullifies the action of dismissal. Do I get you correctly, Mr. Murray? Yes, sir. Judge Aberdeen, I'm merely asking you whether or not, in fact, the failure nullifies the decision, but whether there was indeed a failure. Do you understand me? Yes, Ms. Ledgerwood says. Judge Aberdeen, they are saying that you failed to give the information about the decision 10 days after the 23rd of January 2007, and that failure renders your decision to dismiss. The words, dismiss, null and void. I imagine the effect of that, they are saying, is that he ought to be reinstated. Is that so? Yes, sir. And yes, it is true that in the later written submission it was not dealt with in that way, but in the course of the exchange with the court, insofar as oral submissions also have to be taken into account, the point was dealt with. Page 140. And again, it's dealing with this point about the unpaid suspension, insofar as it was expressly dealt with in oral submissions. This is line 11 to line 21. And the way in which it was dealt with, Mr. Riley had been on unpaid suspension for that period of time, up to 9 years. Numerous applications made by the union, beseeching them to please ask the appellant to be willing to see if they would allow him to be on full pay, half pay, I think even went so low as say quarter pay. And they got no response. And then page 142. And again, this all goes to the breach of the collective agreement, which is the subject matter of the complaint, the first trade dispute. Page 142, lines 9 to 20, explaining that Mr. Riley did not get the money, not at all 1 cent. Is there any provision in the collective agreement for that? There is no such provision. That is suspension without pay. And then, again, the point specifically dealt with, page 143, the very next page. The judges are asking whether there is any provision for suspension without pay. And where it says line 18, that's Mr. Murray. In fact, that should be Judge Aberdeen asking the question, entitles the employer to suspend pending contemplation or while he's contemplating taking disciplinary action. Is there anything that says while contemplating taking disciplinary action, you can suspend without pay? And Mr. Murray deals with the point. It doesn't say payment amount, it says you can suspend. And then dealing with the respondent's case on suspension, page 145. Lines 17 to 26. First line, so it goes without saying that if there is no provision for whether it is half pay or quarter pay, that is the understanding that this worker would be on full pay. I don't deal with the rest of it, but it is there for the board to see. And then the last line, it was not done in this document, referring to the collective agreement, and one could only be left to interpret that to mean that the worker was supposed to have continued to receive his salary. That is clearly our case on that part. And there was never any submission by the appellant that Mr. Riley should have been, or there was power to suspend him without pay, as we understand it. We've already taken the board to the Belize case. In relation to the defence force pay, could I invite the board to page 151? There's no suggestion, I don't think it is being suggested, that the issue about him working for the defence force was ever concealed. Page 151 to line 14 to 20 deals with Mr. Murray's submission before Mr. Riley gave evidence that he was working as a voluntary soldier. (153), which is relevant to the second order made by...
Well, Mr. Murray doesn't seem to deal with the point that's being made. They say to me, well, Mr. Murray, you know he got some money there, so we can't give him all this money here. I said, hello, he's a part-time soldier.
Yes, I'm going to take a look to Mr. Riley, if I may.
Yeah.
If we can turn to... page 223. So those are the submissions. But if we turn to 223, this is the evidence, I believe, of Mr. Riley. And this is why we say that it would be plainly wrong to remit for an assessment of damages because he worked for the Defence Force. If you look at 223 lines 30 to 42, re-examination by Mr. Murray. Mr. Riley, as a volunteer soldier, were you entitled to the same benefits as a regular soldier most of the time? Yes.
Sorry, is this 223?
223 of the bundle. So confirms working as a volunteer soldier. 41, whenever he's required, they call and he goes. And then the top of page 224 is the important part, we say, as to why there's no question of remitting this to the industrial court. When you say available, is that during the working time of the corporation? Answer, no. Well, if it is within that, they will give me a letter which I will carry to the CPO. They will acknowledge it and I will work the time at the Defence Force. Question, and the CPO will allow it? Answer, yes, without any loss of pay. So even if he was working for the Defence Force during his time as an employee of the municipal corporation, once he produced that letter, he would have been on full pay. And that evidence, I should point out, was not challenged. It was given in re-examination, but it was never suggested by the appellant that that was an incorrect practice. So where the appellant now says that he should give credit for his work with the Defence Force, well, that we say would have been inconsistent with the pre-existing practice, that he would not have had to do so if he was a full-time employee.
I got the impression from these exchanges that when he was working for the appellant, he did bits and pieces for the forces.
Yes.
And there was no docking of his regular pay.
That's right.
But he may have done more than bits and pieces.
He may have done more.
After he was suspended.
Yes.
So this doesn't carry the matter very, very much further forward, does it?
It doesn't, but in terms of the suggestion that he should give credit for the Defence Force pay as opposed to driving a taxi in the evenings, we say that that wouldn't have happened anyway. So, in any event, that having been dealt with in evidence, there's no reason why there should be any docking of pay, as my Wilson has said. Lord, can I deal with this point that has been made about exoneration? The relevant article, Article 16, talks about reinstating without loss of pay if the charge has been dismissed or if he's been exonerated. That we agree. The suggestion is that Mr. Riley had not been exonerated, and I think the way the appellant puts the case is that they could not continue with the disciplinary proceedings. We say that that is wrong, because once the industrial court made the order rendering the disciplinary proceedings null and void, nothing about it could have survived. And we say it in our case, that it's as if those proceedings never happened, because it's difficult to see how if you've lost the right to discipline the worker, how anything that has taken place once you instituted the disciplinary process to the ultimate sanction of dismissal could have survived. And so in terms of exoneration, which would allow him to have reinstatement on full pay pursuant to Article 16, he has been exonerated because it's as if those proceedings never happened. And insofar as the issue of exoneration was considered, could I give you these references? It's 250. And it's, forgive me, 249, bottom of the page. Line 39 to 41. This is the evidence of Mr. Samuel, the former CEO. When you say exonerated, what do you mean? Corporation failed to prove its case. I'm sorry, 249, bottom of the page, 39 to 41, sorry.
Thank you.
Sorry, who's talking to who?
This is the former CEO, Mr. Samuel, being examined in chief by Miss Ledgerwood.
Yes. And what's your point?
Well, the short point is, if the corporation, if the understanding of exonerated, absent it being defined in the collective agreement, is that they failed to prove their case and the proceedings were a nullity, there's nothing to look at. There's no adverse judgment, adverse liability finding against Mr. Riley. So he has, for the purposes of the collective agreement, been exonerated, and so pursuant to Article 16, in any event, he'd be entitled to reinstatement without loss of pay. I know the appellant says that he's not been exonerated, but we say he has been, and we draw the board's attention to those matters. Again, for reference, 366. Please. this was the evidence of Miss Alexander having been given instructions from the Chief Personnel Officer. It's page 366, lines 31 to 36. And it all goes to this point that it should be remitted for damages. Could you tell us what was the outcome of the request to have the workers' pay restored? The direction was the matter to be continued, that's the disciplinary proceedings, and that the collective agreement provides that in cases where the defendant is exonerated, that he would be paid full pay for the whole period during which he was on suspension.
Yes?
So we say that that being the evidence given, the industrial court had plenty before it to make the orders that it ultimately did. And finally, on this point, page 367, lines 24 to 28. Which is essentially the same point.
Yes?
Could I just have one moment, my lord? I may have page 504, which is in the second bundle of records of people. Sorry, it's page 500, forgive me, page 506, lines 30 to 35. And this is cross-examination of Warrant Officer Dillon in relation to the pay. The short point is this. The evidence that he gave, he could not confirm that Mr. Riley actually received the pay on a regular basis. And in fact, what was put to him is that he was paid 6 months in arrears. And so, yes, he may have been working for the Defence Force, but he was not regularly paid from that employment. And I deal with that really just to clarify, because I know Mr. Knox agrees that there was some suggestion of delay, but Warrant Officer Dillon could not actually say when they were paid. He could only confirm that he had been paid a certain amount over a period of time.
Your study of this long transcript over the 4 years is magnificent, but I wonder whether these tiny points picked out over the years really help.
Well, I'm grateful to my Lord's observation.
Yeah.
I'm actually coming to an end. If I can have 2 minutes, I think I'll probably finish.
Yeah.
Could I invite the board to look at page 526? It's, sorry, page 528. And it's lines 6 to 11. And this was the issue in relation to pensions arising from the Defence Force. What was put to Warrant Officer Dillon was that you're not entitled to gratuity and pension as a member of the reserves. And he was not able to confirm that. And so there was no evidence put before the court, certainly, that he would obtain any pension rights. And so this is why I say the second order made by the industrial court, back pay, no loss of benefits, etc., is important, because he does not on the evidence that we have, and on the information we have, qualify for a Defence Force pension as a volunteer soldier. Could I simply give the board these references rather than turn them up? It's page 532.
Oh, sorry, what are we on now?
Oh, this is the closings. I've gone through the record really to show those points as relevant to the second order of the industrial court and why this board should not interfere. In relation to the issue of reinstatement, Mr. Knox makes a number of points in relation to the closing submissions. And he's taken the board to some of those.
Yes, and you want to show us references to show what?
Essentially,
there's no point in us chasing around references unless we know what we're looking for.
I'm trying to take the hint, my lord, just to confine it. I think probably I've spent so much time on this, I want to tell everybody what it says, but I should...
Yeah, well, you've precisely 2 minutes in which to tell us.
Could I invite the board to look at 549? And again, it's a curiosity that goes to the issue order number 1, reinstatement, and number 2, back pay. 549, line 22, bottom of the page. Judge Aberdeen. In other words, did Mr. Samuel's consideration, feeling sorry for Mr. Riley, this is when he instituted the disciplinary proceedings, and giving him a chance to prove himself as innocent, did that action serve to reinstate him? Answer from Miss Ledgerwood, well, yes, in the sense that he would have had to see him as an employee for him to face the charges and to answer the charges. Judge Aberdeen, so he was reinstated then? Answer by the Appellant's counsel, well, at that point of relenting. And we simply draw that to the board's attention because on the face of it, the appellant seemed to be accepting at that stage that to carry on this very lengthy disciplinary procedure, Mr. Riley was reinstated to his employment. Well, if that's right, we don't simply have suspension without pay, we have re-employment without pay, because he wasn't paid during that period. And so having regard to all of those factors, when one looks at the orders that were made by the industrial court, what it comes to is that there was certainly sufficient information before them, in the evidence, in the submissions, and in the skeleton, that would have enabled them to fashion a remedy pursuant to Section 10, subsection 3, that was fair to Mr. Riley. That is all they have done, particularly bearing in mind the delay. And we say that for the reasons we've set out, and the case of Illuminat in particular, even though there wasn't a separate remedy hearing, there was plenty of opportunity for the appellant to have made representations on the remedy, and having used the first dispute and the result in it to discharge the second dispute, we say that you cannot now turn around and say that that relief should be set aside.
The tribunal, of course, said the employer has waived the right to impose discipline on the worker. And very importantly, but very realistically, Mr. Knox accepts that that was a reasonable thing for the tribunal to find. Does it follow from waiver of right to impose discipline that he should be reinstated? Mr. Knox rather indicated, well, that then gives rise to a great debate about whether there should be damages. But is that right?
No, we disagree, because if you have lost the right to discipline the worker, that goes from when you suspended him right through to when you terminated him.
Yes.
And so I think it was my Lord and Lady Arden who asked the question. Once that has been rendered a nullity, what is Mr. Riley's status?
Yes.
Well, his only status can be that he was an employee. So the only order that the industrial court could make, because they had that letter of the 4th of April 2008 terminating him, was to say he's got to be reinstated, because that follows from their findings, which are not challenged on this appeal.
Thank you.
Can I assist the board further?
Yeah, thank you very much.
Thank you very much.
Mr. Murphy, would you like to follow? Yeah, thank you very much. Right, Mr. Knox.
My Lords, if I can take these points just one by one pretty quickly, I hope. First of all, my learned friend took you to some correspondence at page 103 and 109 of the record to say that it was clear that questions of pay while suspended and reinstatement were part of the first trade dispute. My Lords, my Lady, the difficulty with that is that this correspondence was correspondence from 2004, I think, and 2006, well before the trade dispute came into existence. And these documents at 103 and 108 were exhibits, no more, to the complaint made by the union. And they're saying, look, it's taken an awfully long time, but you cannot read into, just take, for instance, 103 by way of example, you cannot read into 103, this being an exhibit to the complaint, you cannot read into this that the trade dispute itself has suddenly expanded. It's simply a document which they're bringing in saying, we have been complaining about delay for a long time, and it's all jolly unfair. That's all it says, and the same applies to 109. Second, I submit one has to bear in mind the law. What is a trade dispute? There is quite a formality which I took you through this morning. It's not just something which the parties can raise. It goes through the minister. There has to be an attempt to settle it. You then have a specific document which is set out, which describes the nature of the trade dispute. And I took you to that this morning at page 36, and it's a succinct, fairly simple document, and there's no doubt what it actually says. If I may be forgiven for going back to it at 36, because it is important. What was the dispute? And this is where the jurisdiction of this court emanates from. It's not just some sort of optional thing. It is simply, page 36, the dispute as reported by the union concerns the failure to follow the grievance procedure, Article 16, in respect of the tribunal of Daniel Riley. That is all it is about. It is not about questions of remedy, what sort of damages should be assessed, whether it's reinstatement and so on. That is not part of the dispute, especially because we know there's a second trade dispute which is made on the 25th of May 2008, which is at bundle 2, page 591, which comes about before any of the proceedings actually get going. So we all know what the first trade dispute is. It cannot be said it suddenly expanded. And I just give the references. This was emphasised by objections made by Mr. Murray, A, to consolidation, which is at bundle 1, 279, line 13, and also an attempt by Mr. Samuel, by my client to get in the record of the disciplinary proceedings. And that's at bundle 1, 227. And the point was taken, you cannot expand. Perhaps I should take you to that while I'm in bundle 1. The point is taken at 227. I think I'm right in saying. I'm feeling sometimes my numbering picks out the wrong number. I have it 1917. I think I've given you a bad reference because, my Lord, forgive me, it's a bad reference and I'll just have to forego it. I think it's just a bad reference. So that's the first point. But anyway, the objection was taken. Don't try to get any of this evidence in about what happened before the tribunal, because that's not for now. The second point is natural justice, and this is a fundamental point. It's said that the chief personnel officer, my client, knew what this dispute was all about, and reference is made to pages 37 and 39 of the record. My Lord, we knew what it was about, but we did not know, and there's nothing to indicate that we knew it was going to be about the question we're now talking. And the only indication is that reference which Mr. Parallel took you to when, at the beginning, no more, the tribunal obviously has got it in its head that your claim surely is presumably this is all a nullity, therefore you want reinstatement. It's only the one word yes that Mr. Murray says. Before and after that, it just doesn't come at all. No one talks about it. And that, in my submission, is very important because it's a straightforward breach of natural justice. And the reason I say that's important, because if we're right in saying there's a breach of natural justice, there's an excess of jurisdiction. If we're right in saying there's an excess of jurisdiction, we don't get into this question of necessarily damages. I'm, as it were, saying that's the obvious answer to this case, but my clients were perfectly entitled to take their stand below in the Court of Appeal. May not be the most attractive position, but technically they were right in saying this order was made in breach of the rules of natural justice, it was an excess of jurisdiction, full stop. You're entitled to say that. It was then for the respondent to say, well, if that's the case, give us some damages. And the problem is they didn't say, give us some damages. That is underlying it all, what has really gone wrong in this case. But I do want to emphasise it's not a case of us where we should have offered damages. It's we were technically perfectly entitled to say excess of jurisdiction out. At that point, the respondent should pipe up and say, OK, well, give me some damages. Now, the Court of Appeal did ask the respondent, why didn't you? Why haven't you cross-appealed? And they had no real explanation. If I can just give you the reference, I think it's at Bundle 2, at 600, I think it's at 599. Sorry, 660. You can see about 2/3 of the way down. This is in the union submissions. And obviously the Court of Appeal was straight on to the point about, well, what do we do about the second set of proceedings being kicked out? And about 2/3 of the way down the page, line 32, Mr. Justice of Appeal Jamidar, because on December the 19th, you could have been under no illusion as to what their intent was. Now that, in other words, by that stage we had appealed against the first order. And what they're talking about at this point is the status of the second proceedings. Mr. Taylor, yes, my lord, Justice of Appeal Jamidar, maybe the union on December 19th may have felt the local parliament set up, justifiably so. Well, let us assume all of that. Here is where the rubber hits the road. What did they do? That's right. My lord, from all of the information and instruction I have, it appears that no active steps were taken to challenge it. And then the discussion goes on. 600 to 661, line 30. Now, the difficulty with all this is, I accept my position is unattractive. When you look at it in the round, of course it is. But it's not totally my fault it's got to this stage. The answer was actually for the respondent, and the union, after all, is representing him, this union representative here, to say, OK, I'll put in a cross appeal.
Why? If you're going to win an appeal, if you're going to successfully defend an appeal, why bother with a cross appeal?
Well, you may or may not. That's the problem.
Well, sometimes cases like this, you might think you were going to win on the
well,
appeal.
You take, my lords, I'm afraid it's one of the unattractive features of adversarial litigation is that you take risks.
Indeed.
I accept all that. If only this point had been considered in the Court of Appeal. But the strict position is we were entitled to take the excess of jurisdiction point. It was then for the respondent to come forward and say, right, and if that's right, I'm jolly well appealing against the second order. And there wouldn't have been any answer. The Court of Appeal go on to say there wouldn't have been any answer, would there? Well, I fully accept there wouldn't have been. There it is. My lord, the next question I wanted to address is the suspension. A suspension must always be with full pay. Well, my lord, no doubt that is the general rule. But there's no rule that says that where you are suspended, let's say I'm suspended from my job working in one financial institution, and that goes on for, let's say, 2 years, and I then go off to another financial institution in the meantime while I'm suspended and make more money than I would have got with my employers. I'm still ready, willing and able to come back to my employers, but while I'm actually working, I'm working full-time at the other employer. Now, my lord, there is no authority that says you don't have to give a credit in those circumstances. And in my submission, the reason is this. It's an implied term of your right, generally, of your right to payment on any given day, that you are ready and willing and able to work on that day. And if I'm just simply earning a fortune somewhere else, and I'm not available for work on that day, I may not have given up my employment, but I've certainly given up my right to be paid the salary, if you're taken on a day rate, for that day. And that, I submit, is the answer. And of course, you're entitled to be paid while you're suspended, but not while you're earning a lot of money elsewhere, because the condition precedent to your right doesn't exist. The third...
What do you say about illuminat?
If
It's in Trinidad.
Well, what I say about Illuminat is this. This concerns, quote, the duty, I say duty to mitigate. In other words, the general obligation, the employee's got to go out and see what he can do to get a better job somewhere else. Illuminat says that that's not a rule of law which needs to apply to us. I accept that. Now, there are a couple of points, though. First of all, it is not talking about actually avoided loss. It has nothing to do with avoided loss. There's a difference between saying you're under a duty to mitigate, a difference between saying you don't have to mitigate because it's difficult and so on. It's quite a different thing to say, well, you have actually avoided all your loss and you don't have to bring that into account. That's a very different point. Because at that point, the causation there's simply no causation. You're awarding someone some money for something he hasn't lost in the first place. And my lords, without taking too much time on Illuminat, in a sense it's a policy decision. It's tough, if you're sacked, to find another job. To have a rather rigorous rule about saying you've got to go out and earn it, and you've got to show what you could have done, and to the extent you can't recover, and things like that, that's inappropriate in industrial relations. So one can understand how the notion of a duty to mitigate in industrial relations, at least to a certain extent, is not an attractive notion. And in Illuminat, I don't have time to go through it now, but they talk about sort of like a tariff. You award at least 2 months or 3 months worth of loss, even if you could have gone out and earned some money in the meantime. That sort of thing. All that makes sense. It may even be, my lords, my lady, let us say in this case, supposing Mr. Riley had gone out and earned some money for 2 or 3 months. It may be in those sort of circumstances one would say, well, that falls within the general wide discretion which the court has under Section 10. But we're now talking 10 years. Well, that is very different indeed. And Illuminat doesn't support that. Well, can I just mention this? In Illuminat, the worker was asked for $113,000. In fact, he was awarded $75,000. And we were not talking the same sort of figures, same factual scenario at all.
Yes, and there are other distinctions, such as whether the duty of mitigate is relied on because it's being said that somebody ought to have got a job.
Yes.
This is a case where he did get a job. But on your last point, that it couldn't have possibly have been considered to be appropriate to have no allowance for earnings, where somebody was, as it were, out of work for so long. But the fact is he wasn't reinstated, was your problem. It was your actions, and you could have gone back to the court and said, well, look, let's have a different order while we pursue all these appeals.
Well, my lady, I was going to come to that as a separate point. In other words, was our right course of action back to the industrial court or not? Can I just, before I come to that, I'll come to that now. I'll just move. The difficulty with that argument is that, on the face of it, this was an order that was a final order. And the industrial court is a creature of statute, where one asks, is the jurisdiction when a final order has been made, to go back and say, well, I want you to do something else, please. It was in my submission a perfectly proper course to go to the Court of Appeal, as we did, and say, this order was made without jurisdiction, because it's an order on a subject we weren't even aware of.
Well, if a court fails to do something, does something without giving a reason, or fails to do something, consider something it was asked to consider, then one is entitled to jump up and say, what about this other point?
I would accept this much. You could always ask. Whether you'll get anywhere is another matter. They might say, I'm afraid Sam fucked us. It's not that straightforward. One knows from one's own practice. The question is often, should I appeal or should I complain about this to the court?
It's both, I would think.
Well, maybe. I submit that's taken too narrow a view of the position. On the face of it, this was a final order. The natural remedy was to go off to the Court of Appeal with the complaint we made. We can't be criticised for exercising the statutory right on the basis that there might have been some procedural possibility of going back, asking for an alteration in the award. So I accept it's a point, but it's not a conclusive point.
But you had no fallback. You went for a particular form of relief in the Court of Appeal, but you had no fallback if you lost on that.
Well, in the Court of Appeal, I accept we take the excess of jurisdiction point, which is a clean point, which doesn't involve a fallback. We have the second point, which is irrationality, illegality, which does involve the fallback of saying, well, there should have been a deduction for credit. There should have been a credit. Sorry, credit should have been allowed. That would have been the fallback on the irrationality point. I accept in the Court of Appeal we don't take on our irrationality stroke error of law point the fallback position on back pay. But I do emphasise our main position in the Court of Appeal was entirely justified. This is just an order that couldn't have been made. It just couldn't have been made. Now, if the respondent wants to come along and say, well, give us another order, that's fine. There's a different consideration for the irrationality point. That's what it comes to. The question was raised about the problem about the pension. Well, in my submission, that doesn't necessarily arise at all. That can be dealt with by an award of damages. And if there's any question of, if one assumes for the moment there's damages to be assessed, as I say, then on the face of it, there'd be nothing, as I understand it, to stop the respondent saying, right, well, I want an interim award, please. Keep me going. And those damages, I should say, should involve putting me into the position that I would have been in by way of pension, giving me a sufficient sum to do that. In my submission, that's not an answer to say it's all a bit difficult because of the pension provision. You simply award damages to cover the pension point. The next point my learned friend took was the powers of the court under section 10.3, the general power to do justice. Well, that obviously is subject to, by the statute itself, is subject to excess of jurisdiction arguments and so on. So that doesn't take you anywhere. As far as the, I think I've gone through. Oh, can I just mention one point on McLaughlin, which is an important point. McLaughlin is a case where throughout the relevant time, Mr. McLaughlin was ready, willing, and able to perform his job. Now, I'm not disputing that. I'm not saying you can't make a finding to that effect in this case. It's not. There's no express finding. But what I do say is significant is, although he was ready, willing, and able to perform his job, he still had to give a credit.
He was willing to give a credit. The court proceeded on the basis that he was willing. The point did not have to be decided.
Well, in my submission, it wouldn't have ordered it if it wasn't appropriate to do so. But the point is, it's a case where a deduction has been made, notwithstanding the fact that the employee remained ready, willing, and able throughout the contract to perform the contract. But what he's done, and it emphasises the point I was seeking to make earlier, it's a case of where you have an employee who continues, or office holder, who earns money elsewhere. For the time he's earning money elsewhere, he has to give, or is ordered to give a credit. And I submit it emphasises the fundamental relationship between the notion of a right to pay and a right to being ready, willing, and able to work on that particular day. That's the logic of it. It's not some sort of general principle of, oh, I'll pick a figure out of the air. There's a genuine point behind it. Now, my lords, I'm not saying you have to decide this point now, but I am saying this is a genuine point which would have to be considered on any assessment of damages. My lords, I think I've only got just two other things. The question of miscarriage of justice. I obviously accept that we go and get the second action struck out because of the decision in the first. I do respectfully submit if one's asking about miscarriage of justice, one has to look at the conduct of both parties. The respondent was not a hopeless person without representation or anything like that. He had expert representation all the way through. And one does ask, why didn't the union simply cross-appeal? This was the answer. And one cannot help but notice that there's a reluctance on the part of the union to get the two issues or two trade disputes heard at the same time. Because the difficulty about appealing on the second, against the second, would have been automatically you get into the damages point. And I respectfully submit, my lords, you should not assume it's some sort of hopelessness or lack of funds which brought about the absence of an appeal against the second decision. It has to have been, on the face of it, a reasoned decision, taken for reasons we don't know what they were. think, my Lords, there's one other point, and that is the point about pay. Can I just ask you to look at page 223 in the first bundle, please? This is the second, as well, round of cross-examination. And the relevant passage begins at 222, when he's asked about working as a volunteer soldier. But at the top of 223, he's asked, could you tell us what you were paid? Answer, if you work a month, you get a month's salary. If you work a week, you get a week's salary. How much? Month's salary average about $9,000 if you work the whole month. Did you work the whole month, May? Yes. Plenty of times I worked right through. So since the incident, did you work as a full-time volunteer soldier? Most of the times, yes. Then re-examination. From my experience, re-examination is a dangerous game, and this was a dangerous game in Mr. Riley's case, or Mr. Murray's case. Question, Mr. Riley, as a volunteer soldier, were you entitled to the same benefits as a regular soldier? Most of the times, yes. As a volunteer soldier, and so forth. So he then goes on to explain how there'd be a presidential call-out and things. So this is, I emphasise this on the miscarriage of justice point. This is a real point in the case. It's not a sort of fanciful, maybe they could have done it differently. My Lords, I think that deals with all the points of fact. As far as jurisdiction is concerned, can I just summarise my position in 3 short propositions? First, the Industrial Relations Act 1972 was passed in the context of the 1962 Constitution, which provided for a right of appeal from any decision of the Court of Appeal, essentially. The relevant section is section 82, and it's at page 816 of the Authorities Bundle. And a similar but not identical provision is found at 835 in the 1976 Constitution, which gives the right of appeal in any civil proceedings. And the significance of civil proceedings is that is the phrase that was considered in the sundry workers case. And these are plainly civil proceedings. So I submit the Constitution gives a plain right of appeal. Secondly, and it's part of this point, there's nothing odd in the notion of a right of appeal to the Privy Council in relation to an order made by the Court of Appeal, when the Court of Appeal itself is exercising only a limited jurisdiction. That's exactly what sundry was about. There's nothing odd in that. My Lords, my Lady, I'm not going to go to them, but the references in sundry which are worth looking at on this point if one gets into it are pages 1007F to 1008G, and then the arguments at 1009 and the conclusion at 1010. That's where you see arguments about the Constitution and very similar provisions. It's not identical, it's quite difficult to disentangle, but broadly you can see what's going on.
So you maintain reliance both on Section 109 of the Constitution and Section 18 of the Act?
Yes. Yeah. And then finally, I do make this point. Assume everything against me. It's at best ambiguous, what is in Section 18.4. It's certainly not a clear ouster. Let's assume for the moment it's ambiguous or not totally clear. It's a well-known rule of construction that you do not assume a constitutional right has been taken away without clear language. That's clear, and it's obviously not clear language. And the second thing I say is that it's very odd to have the notion of a constitutional right being taken away when, by a special majority of 2/3 and 3/4, when you've specially turned your mind to the need for a constitutional majority in a different context, and referred only to that particular constitutional question in the preamble, not to, in this case, the relevant one. And so I submit that that's an end of it. As far as the equal opportunities case is concerned, my learned friend, there's one short answer. Section 50, subsection 5 of the Equal Opportunities Act has a clear ouster.
Yeah.
So, in other words, it's structured in a very similar way, funnily enough, to the Industrial Relations Act, but with a clear ouster in Section 50, subsection 5. And that's the obvious distinction. My Lords, unless there's anything else, my Lords, there's...
Thank you very much indeed, Mr. Knox. The board is very grateful to counsel for their very helpful submissions. We will take time to consider judgment, and the court is now adjourned.